Assalamualaikum warahmatullahi wabarakatuh. My name is Kerajaan LAB2013 and my metric number is 1250911. So today I will be presenting a case that I have chosen for review, which is the case of Elin Zurina binti Abdul Rashid and another versus Kerajaan Negeri Kelantan. So first and foremost, we need to know the parties involved, which is this case involved two applicants, which is the Elin Zurina binti Abdul Rashid and another who are Muslim residents of the state of Kelantan. So the next is the respondents include the government of the state of Kelantan. So this matter brought directly before the Federal Court of Malaysia, which is the highest court in the country for constitutional interpretation. So my next point is the facts of the case. So this case arose when the State Legislative Assembly of Kelantan enacted the Sharia Criminal Code Enactment 2019. So this enactment introduced a series of Sharia criminal offences applicable to Muslims in the state of Kelantan. So among these provisions enacted were offences relating to sexual conduct, causing harm, false statements, attempts and other forms of conduct punishable by fine, imprisonment or whipping under Sharia law. So a total of 18 provisions under the enactment were subsequently identified as being potentially problematic from a constitutional perspective. So therefore, the applicants in this case, which are Elin Zurina and another, were Muslim residents of Kelantan. Although they had not been prosecuted under any of the impugned provisions, they contended that as Muslim living within the state, they were subject to and exposed to the operation of the impugned provisions. So the applicants filed an originating application directly to the Federal Court under Article 128 Clause 1 of the Federal Constitution. They are seeking a declaration that the impugned provisions of the Sharia Criminal Code were unconstitutional, null and void. The objective of this case review are to examine the constitutional limits of state legislative power, particularly in relation to Sharia criminal legislation enacted by the state authorities. And second, it seeks to analyse the division of legislative competence between the federal and state governments as provided under the Article 74 and the 9th Schedule of the Federal Constitutions. And another objective of this case review is to explain that the power of states to enact Sharia laws is not absolute and must remain within the limits set by the Federal Constitution. Next part is identify legal issue. The first one, whether the Kelantan State Legislative Assembly had the constitutional authority to enact the impugned provisions under the state list. So the second one, whether the impugned provisions are criminal law in substance, thereby falling under the federal list. And lastly, whether the impugned provisions are therefore ultra vires the federal constitutions and void. So next, we go through the applicant's arguments. So the applicants submit that the Kelantan State Legislative Assembly acted beyond its constitutional powers in enacting the impugned provisions of the Sharia Criminal Code Enactment 2019. So firstly, the applicants argue that criminal law falls exclusively within the legislative of Parliament. So this is expressively provided under Article 74, read together with the list 1 of the 9th Schedule of the Federal Constitution. While Islamic law is placed under the state list, their power is not absolute and must be exercised within constitutional limits. The second argument is they emphasize the doctrine of peace and substance. The court is urged to look beyond the level of Sharia and examine the true nature and effect of the impugned provisions. So when examined in substance, the provisions criminalize conduct such as causing harm, sexual acts, false statements and attempts. All of these are classic subjects of criminal law. So therefore, despite their religious framing, the provisions are criminal in substance. So third, the applicants submit that several of the impugned provisions overlap with the provision that are already provided under federal law, specifically in the Penal Code. The next argument is the applicants rely on Article 4 Clause 1 of the Federal Constitution, which established the constitutional supremacy, which means that any state law that is inconsistent with the Constitution, including the distribution of legislative power, is considered as void. And finally, on the issues of locus standi, the applicants submit that they have sufficient standing to bring this challenge. As Muslims residing in Kelantan, they are subject to and exposed to the operation of the impugned law. So the applicants are not required to wait until they are prosecuted before challenging the constitutionality of the law. And now, let's go through the respondents' arguments. So the respondents submit that the Kelantan State Legislative Assembly acted within its constitutional authority in enacting the Sharia Criminal Code. So first, their point is the respondents argue that Islamic law is placed under the state list in the 9th Schedule of the Federal Constitution. The Federal Constitution therefore recognizes the power of state to legislate on the matters of Islamic law, including offences regulating the conduct of Muslims. So second, the respondent emphasized that the impugned provisions apply only to persons professing the religion of Islam, which means that the enactment does not constitute general criminal law applicable to the public at large, but rather a form of religious regulation confined to Muslims. And thirdly, the respondents submit that the impugned offences are religious and moral in nature, which is grounded in Islamic jurisprudence. The purpose of the enactment is to preserve Islamic morality and discipline within the Muslim community, rather than to function as an ordinary criminal law. And finally, on the issue of locus standi, the respondents argue that the applicants lack standing as they have not been prosecuted under the impugned provisions. In the absence of actual injury, the challenge is said to be premature. So for these reasons, the respondents submit that the application ought to be dismissed and the enactment still upheld. And the next part is the court judgment, which is the federal court by a majority of 2 to 1 allowed the applicant's constitutional challenge. So the majority held that the 16 out of 18 impugned provisions of the Sharia Criminal Code Enactment 2019 were unconstitutional and void. The court found that although the provisions were framed as Sharia offences, their true nature and effect revealed that they were criminal in substance. And as criminal law falls within the exclusive legislative competence of Parliament under Federalists, the Kelantan State Legislative Assembly had acted beyond its constitutional powers in enacting those provisions. So therefore, the provisions were ultra vires the federal constitutions. And on the issues of locus standi, the court rejected the respondents' preliminary objections, and the majority held that the applicants, as Muslims residing in Kelantan and subject to the operation of the enactment, had sufficient standing to bring the constitutional challenge, even though they had not been prosecuted. The primary law applicable in this case is the Federal Constitutions, which governs the distribution of legislative powers in Malaysia. So first, Article 4, Clause 1. This article established that the Federal Constitution is the supreme law of the Federation, which means that any law enacted by a state legislator that is inconsistent with the Constitution is void. And the second one is Article 74, read together with the 9th schedule. These two sets out the division of legislative powers between Parliament and the state legislatures. So under the Federalists in List 1, criminal law and criminal offences fall within the legislative competence of parliaments. So in contrast, the state list in List 2 permits states to legislate on Islamic law applicable to person professing the religion of Islam. And number 3, the Article 128 Clause 1 confers jurisdiction on the Federal Court to determine questions relating to the validity of any law and to interpret the federal constitutions. So this provision forms the procedural basis for the applicant's constitutional challenge. So in terms of legislation, the impugned law in this case is the Sharia Criminal Code Enactment 2019 of Kelantan, which introduced Sharia criminal offences applicable to Muslims in Kelantan. And for contextual comparison, the Penal Code represents federal criminal legislation enacted by Parliament and highlights the constitutional separation between federal criminal law and state criminal Islamic law. In discussing this case, several important points can be highlighted. So first, the decision clearly shows that the state power to enact Sharia criminal laws is not absolute, although Islamic law falls under the state jurisdictions. And second, the case reinforced the principle of constitutional supremacy, where any state law that is inconsistent with the federal constitution may be declared invalid. So third, this decision illustrates the tension between federalism and state autonomy, particularly in balancing the state's authority over Islamic matters with the federal government's power over criminal law. And overall, the case demonstrates the federal court's role in maintaining constitutional boundaries while ensuring that state legislation does not exceed its legislative competence. In conclusion, the federal court, in the case of Nik and Zurina, reaffirmed the supremacy of the federal constitution and clarified the constitutional limits of the state legislative power. So, which means that Islamic law remains a state matter, but it must operate within the boundaries set by the federal constitutions. And that's all from me. Thank you.